very warm welcome to the thorough newspaper analysis for the 11th of November, which is presented to you by LawSikho. Now, let's proceed to the agenda for today. So, the first segment for discussion would be the editorial segment. And here we've taken an article from The Hindu, the title of which is Tamil Nadu Governor Holding Back Bills. It is a matter of serious concern. This has been stated by the Honorable Apex Court. So, what is this matter? What the Supreme Court has said? What is the stance of the state government before the Apex Court? That is going to be the scope of today's discussion in this article. Secondly, we talk about the important news updates coming from the national and the international arena. And thirdly, we have a look at the important legal news for the day. Here, we're going to talk about a Kerala High Court statement or judgment, wherein the court talks about the importance of impleadment of necessary parties. So, with this, let's start with the article discussion and let's straight away go to this article, which is titled as this Tamil Nadu Governor holding back bills. It is a matter of serious concern, the Supreme Court has stated. Now, see, let's understand the context of it first. If you remember, in the months of March, April, and May, we did a couple of stories on this entire constitutional deadlock, which has been created by the governors between the governor of a state and the state government. And we saw such instances coming from several states, be it the state of Tamil Nadu, the state of Telangana, then we had similar situation from Kerala, we had it coming from the state of Punjab as well. So in all of these situations, what was happening was that, in the state of Tamil Nadu particularly, the governor was sitting on certain bills and certain other important matters also, where the government, after going through the entire process of passing the bill, the government passed the bill and the bill is now before the governor for his assent. Now what the governor is doing is governor is not giving the assent, governor is not sending the bill for consideration of the president, and the governor is not withholding the bill and returning it to the state legislature for reconsideration. So, all of the three options which have been given to the governor in Article 200, we're going to talk about it later. So, the governor is not doing any of it. The governor is simply sitting on these bills without any explanation for an infinite amount of time. So, what is this doing? This is doing a lot of harm to the administration of the state, and the general public is at the receiving end. So, this is what has happened. And the Supreme Court on Friday, it said that the constitutional deadlock, which is created by the Tamil Nadu governor, R.N. Ravi, by inexplicably delaying or even failing to consider and give assent to 12 crucial bills which are passed by the Assembly, and therefore halting the day to day governance in a way which is threatening to bring administration in the state to a grinding halt, it was a serious concern. Now, let's understand what the Supreme Court did further and the notice that has been given to the Union of India. So, three-judge bench, which is headed by the Chief Justice of India, Dr. D.Y. Chandrachud, it issued formal notice to the Union of India through the Home Ministry to respond to the Tamil Nadu government's petition that the governor was acting in a manner which defeats the right of the people of the state to a welfare legislation. The court asked the Attorney General of India and, in his absence, the Solicitor General of India to be present in court on November 20th, even as Tamil Nadu, which is represented by senior advocates A.M. Singh and P. Wilson, it said that the governor was even holding back files seeking sanction for prosecution of public servants in matters of corruption, and it was also not making any sort of action with respect to pleas for immature release of prisoners and with respect to appointments to the Tamil Nadu Public Service Commission. So essentially, the state, which is represented by these senior advocates, the state contended, this case of the state was that the governor has not been showing any sort of action with respect to these bills, and not only these bills, but also it was it was holding back files which was seeking sanctions to prosecute some public servants in matter of corruptions, and the premature release of some of the convicts that was sought, there was no action with respect to that, and the appointments which were critical appointments like Tamil Nadu Public Service Commission, the appointments to these offer bearers, they were also not made. Mr. Wilson, he further submitted that there was not a word from the governor on any of these files or bills which related to subjects from public health to higher education. So, amid these filings, the Supreme Court then issued notice to the Union of India. The court, in its short order, it also highlighted that Article 200 of the Constitution, it mandated the governor to act as soon as possible when the bills passed by the state legislature, they were presented to him for declaration of assent. The CGI orally observed that the governor could either give his assent, the governor could withhold his assent, in which case, if the bill were not money bill, then the governor returns the bill to the House, suggesting modifications or amendments, or refer the proposed laws to the President. So the three options which have been given under Article 200 are these, and the CGI has also orally observed with respect to that. What are these three options? That let's say a bill, it was before the houses or the house of the state legislature, wherever there is a state legislative assembly or the state legislative council. So let's say both or one of the house, as the case may be, has passed the bill, then it goes to the governor for his assent. The governor can give assent. So that's a simple scenario. Now, if the governor wants to withhold the assent, the governor feels that there's some sort of an issue with the bill. So what can the governor do when the governor wants to withhold it? The governor can return the bill with his message suggesting suitable amendments to the legislature of the state, suggesting amendments. Now, if the state legislature further sends the bill back to the governor, then the governor has to give his assent. Secondly, the governor can reserve the bill for the consideration of the president. So, this has been stated by the CJ. The court said that the governor could not just sit on these bills for an infinite period of time, which has happened in the state of Tamil Nadu. Now, again, let's have a look at the stance of the government, the state government. The council, Mr. Singh, he said that we've been begging the governor to consider these bills, these other actions or files, and we've been begging him to grant sanction for prosecution. We've been begging him for remission. He's doing nothing, Mr. Singh said. Further, Mr. Wilson, he said that 10 of the 14 posts in the State Service Commission, including that of the chairperson, they were vacant. There were 4 files for prosecution sanction forwarded to the governor between April of last year to May of this year. The state said that the governor had positioned himself in a political rival as a political rival to the legitimately elected government. The governor's inactions, they had caused an impasse, which is to say difficult situation of no progress between the constitutional head of the state and the elected government of the state. The governor, he was toying away from the citizens' mandate, the petition said. The state that urged the Supreme Court to declare the inaction, omission, delay, and failure to comply with the constitutional mandate by the governor of the state as illegal and arbitrary. It also sought the court to fix a deadline for Mr. Ravi to consider the bills and orders pending with his office. The state, it accused the governor of politically motivated conduct for denying sanction to probe authorities in corruption cases against public servants, despite finding prima facie evidence against them. I have a question and I request all of you to please put down the same in the comment section. So, who is the appointing authority for the Attorney General of India, and which article says that Attorney General of India has a right of hearing without being a member of the Parliament, but he can sit and attend a proceeding or proceeding in the Indian Parliament? Kindly put down your answers in the comment section. And now we move to the next segment. And now we proceed to the national news category for today. And here, this is the very first update. UK is to include India in its list of safe states. The United Kingdom, it has announced its plan to add India to its list of safe states. This is a move that effectively will limit asylum seekers' rights for illegal migrants from the country. See, essentially, suppose there is a person and he has entered United Kingdom illegally. So he is an illegal migrant. Now, such sort of persons, they have certain rights to seek asylum in United Kingdom. But if the person is coming from a country which is considered as safe, so then the rights to seek asylum, it is curbed and those rights they decrease. So if India is going to be put in the list of safe states, then such an illegal migrant, his right to seek asylum in United Kingdom, they are going to diminish. The decision, which is announced by the UK Home Office, it aims to streamline immigration procedures and to enhance border control measures. Over the past year, the UK it has witnessed a rise in small boat arrivals from India and from Georgia, thus prompting the country or the government to reassess its approach to asylum seekers from these countries. So, what does it mean for India? As I've already mentioned, the inclusion of India in the safe states list, it implies that UK government it considers the country to be generally safe, stable and free from widespread human rights abuses, thus rolling out their chances of seeking asylum in the UK. As a result, Indians who travel from the country illegally, they will have their chances of seeking asylum there diminished. So, what are some of the other countries on this list? Apart from India, the UK Home Office it has decided to add Georgia in its list of safe states. Other countries which are deemed safe by the UK government, it includes Albania and Switzerland, as well as the European Union and the European Economic Area states. So what next? The proposal it will be placed before the houses of the parliament. It is going to go under scrutiny of the parliament, and after having debated on this particular matter, the parliament is going to decide whether to bring it in force or not. Next is this update. The NPCI it appoints Pankaj Tripathi as the UPI Safety Ambassador. The National Payments Corporation of India, it has announced the appointment of acclaimed Bollywood actor Pankaj Tripathi as its UPI safety ambassador. This is to strengthen safety awareness on digital payment platforms. The NPCI, this move, it follows the ongoing discussions regarding the safety and the security of digital payments platforms, particularly UPI, which stands for United Payments Interface. The digital payments ecosystem in India, it has also grown significantly in the recent years, driven by a combination of government initiatives, an increase in internet and smartphone users and the rise of e-commerce. The digital payment ecosystem it is supported by private players who offer a range of digital payment services. Flying Wedge it is first company to secure DGCA certification for unmanned aerial vehicle technology. Flying Wedge Defence and Aerospace, it has become India's first ever private firm to secure a Director General of Civil Aviation type certification for indigenous unmanned aerial vehicle technology. UAV technology essentially is, let's say, a drone. It is an example of this technology. Two of the country's surveillance drones, they are already deployed. Two of the companies, so two of Flying Wedge Defense's drones, they are already deployed in the heart of New Delhi, carrying out observation of airspace and grounds around the Prime Minister's residence. Under the regulatory framework of Director General for Civil Aviation, no drone, aircraft, or aeroplane it can operate in India without the DGCA type certification. The stringent certification process, it is regarded as a vital step in ensuring the safety and reliability of the UAVs within the country. The Indian firms that have successfully obtained this sort of a certification within this sector, they've obtained technology from abroad, predominantly from China. Flying Wedge, it is now leading the way not only in defense, but also in the agriculture sector with their autonomous agricultural drones. Its drones, they've transformed smart farming in India, offering cost effective solutions that enhance crop yield and reduce water consumption. Japanese embassy, it confers Order of the Rising Sun, Gold and Silver Star to retired Admiral Karambir Singh. The Japan Self-Defense Forces Day 2023, it was held by the Japanese embassy in New Delhi. The ceremony, it conferred Admiral Karambir Singh retired, who's the 24th Chief of Naval Staff, with the Order of Rising Sun, Gold and Silver Star for his contribution to strengthening the relationship between India and Japan in national defense. Meanwhile, Union Minister of State for External Affairs V. Muralidharan, he arrived in Tokyo on Wednesday morning. He said that India and Japan, they cherish a special strategic and global partnership which is rooted in ancient historical ties. There is a growing strategic convergence between the two countries. There is a synergy between India's Act East policy, Indo Pacific vision, which is based on the principle of Sagar, and Indo Pacific Oceans Initiative on one hand, and Japan's free and open Indo Pacific vision on the other. India and Japan relations, they were elevated to global partnership in the year 2000, while it elevated to strategic and global partnership in 2006, followed by a special strategic and global partnership in the year 2014. Now let's have a look at an important day which was commemorated on the 11th of November. So every year the National Education Day, it is celebrated on 11th of November. This year the National Education Day, it falls on a Saturday. So today is this a day. National Education Day, it is celebrated on the birth anniversary of Maulana Abdul Kalam Azad, the first education minister of our country. Let's understand the history behind the commemoration of this particular day, which is celebrated today, the 11th of November. Maulana Abdul Kalam Azad, he was the first education minister of independent India. He served the position from 1947 to 1958. His work towards making education better and accessible, it is applauded and respected. His contributions in the field of education and educational institutions, they are remembered. To commemorate the same, the Ministry of Human Resource Development, it announced his birthday to be celebrated as the National Education Day. Since 2008, the National Education Day, it has since been celebrated. And this has brought us to the international segment for today, with this being the first update. Former US astronaut Frank Borman, he dies at the age of 95. Former US astronaut Frank Borman, who made history by commanding the first manned flight to circle the moon and later piloted the Eastern Airlines as chairman in severe economic turbulence, he has died at the age of 95 as per a NASA release. Borman, who spent a total of almost 20 days in space on 2 trips in the 1960s, he died on Tuesday. Born in Indiana on March 14th in 1928, he was the oldest American astronaut still living. That mantle now passes on to Jim Lovell, who is also 95, but he's 11 days younger. Borman, he became an Air Force fighter pilot after his graduation from the US Military Academy in the year 1950. Like most of his fellow generation of astronauts, he trained as a test pilot before being selected for the NASA's second astronaut program in the year 1962. That experience, it was key, he said in his autobiography. So this is a very interesting update and scary for some of us. A Polish alco beverage firm, it has hired AI CEO to lead its operations. The robot, it is called Mika, and it says that she or it is available 24/7 and does not have any weekends. So, in what could be called as the world's first such move, a Polish alco beverage company earlier this year, it has announced that it has appointed an AI powered humanoid, which is human like robot, to lead the firm. Dictador, it announced that it will engage the services of Mika to steer its operations. Mika is a result of collaboration between this firm and Hanson Robotics, which is a Hong Kong based engineering and robotics company known for its development of human like robots with AI for consumers, entertainment, service, healthcare, and research applications. Hansen earlier hit headlines in 2016 with the famed humanoid Sophia, who once said that she will destroy humans. Now, let's see what this robot AI enabled CEO has to say on this entire development. So it stated, and I quote, I don't really have weekends. I am always on 24/7, ready to make executive decisions and stir up some AI magic. The robot stated in a video interview. The company it also released a video where the robot can be seen saying that with advanced artificial intelligence and machine learning algorithms, I can swiftly and accurately make data-driven decisions. My decision making process it relies on extensive data analysis and aligning with the company's strategic objectives. Australian captain Meg Lanning, she announced retirement from international cricket. Meg Lanning announced her retirement from international cricket on Thursday after leading the Australian team for almost 13 years. Lanning, who led the cricket team to 5 World Cup wins, scored nearly 8,352 runs spanning through 241 matches over all three formats. The 31-year-old, she released a statement saying, and I quote, the decision to step away from international cricket, it was a difficult one to make, but I feel now is the right time for me. She further added, I've been incredibly fortunate to enjoy a 13-year international career, but I know now is the right time for me to move on to something new. As far as her cricket career it is concerned, her debut was in 2010 against New Zealand in a T20 match, and she took up the role of captaincy in 2014 at the age of 21. She had a win percentage of 80 and went on to win the 50 overs World Crown in the year 2022 and the T20 titles in the year 2014, followed by 2018, followed by 2020, and this year. Her last international match it was in South Africa earlier this year, where she fittingly led her side to ultimate crown. This is brought us to the legal update segment, which is the last segment for today, where we have an update from the Kerala High Court. Lack of necessary parties, specific averments in writ petition cannot be cured by filing impleadment application. The Kerala High Court it dismisses a writ petition on the finding that specific averments they should be made against the parties while filing the writ petition itself, and they need not be arrayed or added or joined as parties later by filing an impleadment application. The division bench of the High Court it added that the writ petition it lacked specific averments in tune with the relief sought for and the necessary parties were not arrayed in the party array. A mere application for impleadment after the filing of this writ petition, it will not serve the purpose since the writ petition for seeking such a relief, it should contain specific allegations against Temple Advisory Committee and its members. In the absence of necessary averments in the writ petition in support of the reliefs that was sought for, and the necessary parties in the party array, we find no reason to entertain this writ petition, the court added. The name of this particular matter is Gopal Kumar P versus Travancore Devaswam Board. Now, here I have a question: which order and which rule, if you can point that out, talks about the misjoinder of the parties and specifically the necessary party, and also which rule of which order talks about when can you raise objections with respect to misjoinder of the parties, and also which section talks about the same, as in, what happens or what is to be done when the decision has come and there was a non-joined of such sort of parties. Please put down your answers in the comment section. And this has brought us to an end of our TNA for today. Thank you for being with us all this while. And in case you want to get access to the free study material that LawSikho provides and also the TNA slides that have been used in this video, I would highly encourage all of you to please join our Telegram channel. And for the same, you can scan the barcode which is given on your screens, or you can click on the link which is provided in the description. These are the point of contacts in case you want to get in touch with LawSikho. Thank you for being with us. Enjoy your Diwali festival holidays and happy Diwali to all of you.